Good morning, everybody, and welcome back to the fourth and final instalment in Exchange Chamber's webinar series on the Corporate Governance and Insolvency Bill. The bill, as I'm sure you're all aware, was in committee stage in the House of Lords on Tuesday. I expect we'll be hearing some more about that. And the next stage is the report stage in the House of Lords, which is next Tuesday. So we'll see where matters go. The session, this final session, is going to be split between several speakers. First, we've got a couple of very specific topics of things that are introduced by the bill, and we've then got a kind of overall view of the changes to the insolvency landscape from both bar and from an academic perspective. So we're looking forward to that. If you haven't been able to join us on any of the earlier sessions, we will be making recordings of those available. So those may be useful to fill in any gaps that you might have or any further questions arising out of today's session. And we'll also be providing, by way of a download link for you after the sessions, copies of the slides that you're going to see alongside the speakers talking today, and also a delegate pack containing some useful information as well on the bill generally and the temporary coronavirus provisions in respect to the bill. Finally, before I introduce our first speaker, just to make you aware, there is a Q&A button at the bottom of your screen. If you've got questions, if you pose them there as we go along, what we'll do at the end is I'll invite the panel back to speak to everybody, and we will be selecting some of those questions and answering them for everybody to hear. Finally then, if I can turn to introduce our first speaker, Ian Tucker. Ian is an insolvency specialist. He appears regularly in the Chancery Applications list on urgent and contested insolvency applications, but he's appeared at all levels of court, including up to the Court of Appeal. Chambers and Partners described him as exceptionally bright and working well beyond his years of call. He's one of our rising stars. And I welcome Ian now to talk to us about the temporary prohibition on the presentation of winding up petitions. Thanks, Ian.
Thanks very much, Carly. Right. One of the temporary measures brought in by the bill, and perhaps the bluntest measure, is a prohibition on winding up petitions that will now cease to have effect 1 month after the bill is enacted. One of the curious results of how the measure has been announced, implemented and interpreted by the courts is that the measure will have de facto been in effect for a longer period prior to the bill becoming law than after it. Nonetheless, it remains important to understand the nature and effect of the prohibition, both now and in respect of any future extended period announced by the government. So with that in mind, I'll look to cover the aim of the bill, the pre-existing creditor gateways being those gateways that are affected by the bill, the statutory provisions in some detail, and then looking at the 3 cases that have so far considered the bill and announcements by the government to date. The aim of the bill was said by Lord Callanan, a government minister, when introducing the bill for the second reading in the House of Lords. He said that the temporary measure will help struggling businesses by removing the threat of statutory demands and winding up petitions issued against companies during the emergency. This provision will give businesses the opportunity to reach realistic and fair agreements with all creditors. I think we can all agree that that's a laudable aim, if nothing else. By way of brief background, the pre-existing gateways, if you are a creditor and you want to bring a winding up petition against somebody, then you need to allege that the company is unable to pay its debts pursuant to section 1221F of the Insolvency Act. This and this alone is the gateway that is affected, that is touched upon by the bill. That means that other gateways available to other parties to achieve a winding up petition, a compulsory winding up order, are not affected, and in particular the just and equitable grounds and the company special resolution. So when the company is unable to pay its debts, a company is deemed unable to pay its debts if what I call the creditor gateways are engaged: unsatisfied statutory demand, unsatisfied execution, proved to the satisfaction of the court that the company is able to pay its debts as they fall due, and using old school terminology, the company is balance sheet insolvent. So these are the gateways that are affected by the bill, other gateways unaffected. The statutory force for the bill is found in section 8, and all that says is Schedule 10 is where the meat is. So moving to Schedule 10. Schedule 10 Part 1 is a one-paragraph provision, and it relates to presenting petitions based on statutory demands. And what it says is, if you served a statutory demand between the 1st of March 2020 and 1 month after the bill comes into force, call it now the end of July 2020, that statutory demand is useless and cannot be proceeded with. That is the case even after the bill ends, so there is no point in presenting a statutory demand until the period specified by the bill ceases. Part 2 is slightly more nuanced, but it also contains a prohibition on presenting petitions, but this time based on any of the creditor gateways. The prohibition is on presenting a petition unless what I call the coronavirus condition is met. The coronavirus condition, the new gateway that any creditor wanting to present a petition has to go through, is twofold. The creditor has reasonable grounds for believing that coronavirus has not had a financial effect on the company, or the facts by reference to which the relevant ground applies would have arisen even if coronavirus had not had a financial effect on the company. Now, this is an either or. The first, the financial effect test, and the second, effectively a causation or but-for test. And I'll deal with each in turn. The first, the financial effect, the definition section on the bill is extremely brief, but one of the definitions it does include is what is meant for the purpose of the bill by the financial effect. It provides coronavirus has a financial effect on a company if and only if the company's financial position worsens in consequence of or for reasons relating to coronavirus. Now, this is extremely widely drafted. Financial effect worsens without any materiality requirement, and for reasons relating to coronavirus, given the lockdown, given the impact that it has had on consumer activity, public transport, available financing, it is extremely difficult to see how, if a company financial positions worsened during the latter period of the lockdown, which is the relevant period, that could not be for reasons relating to coronavirus. So really, this is just a did it get worse during coronavirus test. The but-for test, the second test, to read it out again, the facts by reference to which the relevant ground applies would have arisen even if coronavirus had not had a financial effect on the company. And in practice, this is likely to be that the company is so insolvent that it would always have been unable to pay its debts. Or to put it another way, coronavirus is not what pushed the company over the edge. But it's difficult to see how a creditor can allege a reasonable belief if the debt would have been serviced out of cash flow. So, for example, shops paying rent, hotels paying rent to the landlords, they would pretty clearly come within the but-for coronavirus condition if their financial position worsened. And if the debt arises on a specific event, then the issue will be whether that event would have occurred regardless of coronavirus. So, for example, liquidated damages on breach of a contract or a transaction, whether a transaction would have completed. What you're looking for is, was coronavirus the cause of that transaction not completed, or that breach arising such that liquidated damages became payable? In my view, it is this test that the majority of creditors, if they can get through the coronavirus condition, will be the one that they are able to get through. So now suppose that you are a creditor and you have asserted that you have your reasonable belief that one or both of the coronavirus conditions have been met. Then a creditor must confirm in the petition that they hold the reasonable belief that the coronavirus condition has been met. Query how they could know. There is no requirement for provision of information, and query what is meant by reasonable belief and what the court will use as a touchstone for that. This hasn't yet been determined by judicially, but I consider that it's going to be akin to, there has to be something of substance that a creditor can point to and say, this thing of substance allows me to hold a reasonable belief that coronavirus is not the cause of the creditor of the company being unable to pay its debts as they fall due. And of course, this bill and the coronavirus condition is not only relevant when presenting a petition, but it can also arise in injunctions to restrain presentation based on the bill. So I query in both cases where the burden will be and to what extent the burden will fall on the creditor. I think it's probably going to be prima facie case on the creditor, with the company then having to satisfy the court on the balance of probability that the coronavirus condition has not been met. But as I say, this hasn't yet been judicially determined. And if that is the case, and given the lack of disclosure and the summary nature of injunctions and petitions, then query to what standards it is in a debtor company's interest to actually provide disclosure or to volunteer information. I was in front of an ICC judge last week, and he gave extremely short shrift to a debtor company asserting that they fell within the coronavirus condition when they had effectively disclosed a handful of emails out of a whole suite, with the judge asking essentially what else was there, why weren't you showing this to the court? So as I say, not judicially determined, but I think that it's a prima facie case for the creditor, and the burden then shifts to the company. Now, one of the reasons I think this is that when you present your petition and the creditor alleges that they have a reasonable belief, the creditor is prohibited from advertising the petition until the court has made a determination in relation to the question of whether it is likely that the coronavirus condition is met. What that means is the creditor presents the petition, and there's then an initial or preliminary hearing at which the only issue is the corona condition likely to be met? If the court says yes, then you can proceed to advertise. If the court says no, then the petition dies a death there. And that's why I think that the burden is likely to be on the company, because the reasonable belief is different to satisfying the court that it's likely that the coronavirus condition has been met. In this period, third-party creditors do not have a right to inspect the court file. There is obviously no advertisement. So even wholly meritorious petitions will be confidential and the subject of significant delays. Also of note, the provisions for void disposition have essentially been dispensed with. The deeming date for the commencement of winding up is no longer the date of presentation of the petition if the petition is presented in the face of the bill, but it's actually when the winding up order is made. That means that the company can continue trading as normal with no advertisement, no creditor awareness of the petition. And if the company is ultimately wound up, then there is no period of void dispositions. There is essentially a quid pro quo for this, with antecedent transactions, the period of antecedent transactions being extended further back. So whilst the period starts when the winding up order is made, it actually goes back for, broadly speaking, 2 years, 6 months. Now in respect of, for example, TUV, it's a 6-month extension. So from 2 years to 2 years, 6 months. There is no similar provision in respect to petitions that would have been presented during the bill but weren't, and I wait to see whether that will be considered by the government. But it doesn't end there. Suppose that the petition has been presented, the court has considered that it's likely that the coronavirus condition is met. There is then a final hearing, and the court cannot make a winding up order unless it considers that the coronavirus condition is met. Now, in my view, this is belt and braces drafting. It adds nothing, because it is a prohibition on the court granting an order in respect of a petition that a creditor could neither present nor advertise. Nonetheless, the government is essentially giving judges very little wiggle room in this and prohibiting them from making a winding up order in this circumstance. The provisions then have retrospective effect, and they are to be regarded as having come into force on the 27th of April 2020. And this has effect in 2 different ways. The first is in respect of live petitions that should not have been presented. That is to say, a live petition that does not meet the coronavirus condition. Then the court may make such order as it thinks appropriate to restore the position to what it would have been if the petition had not been presented. Now, this is obviously a wide jurisdiction and a wide ability for the courts to meet the justice of the situation, but query if it applies to costs, query if it applies to validation, or query how far the court will actually go on this to restore the position to what it would have been had the order not been presented. In respect of winding up orders that should not have been made, that were made but should not have been made because the coronavirus condition was not met, then the court is to be regarded as having had no power to make the order, and accordingly the order is to be regarded as void. Now, in my view, this is the most surprising part of the measure, and it is, in my view, the bluntest of the blunt instruments. It applies in respect of all winding up orders made between the 27th of April and, say, the end of July, when the relevant period ends. And what's particularly noteworthy is that the CIGB, the bill, was only actually published on the 20th of May 2020. That means between the 27th of April 2020 and the 20th of May 2020, there will have been any number of winding up orders made by judges, by practitioners, sought by creditors, who did not know that this retrospective effect was going to come in. Query where costs lie, query how one is meant to resolve the situation where things have moved on since the 28th of April 2020. The directors no longer want the company, they have bought the assets, started a new business. The employees receive redundancy payments that they're not entitled to. Query how far and what interest there will be in actually remedying the situation. One or two things that occur to me is, if it is a situation where there is no competing interest, query if the directors put back in the saddle would be able to, or would be willing to, they would certainly be able to, obtain a compulsory winding up order by special resolution, or query if the court in this situation would actually engage the just and equitable grounds for example, on a liquidator application, query if administration is the answer. But whether there is a desire by the directors to retain control of the company, I have little doubt that they will be able to do so, at least until some other insolvency regime, some other administration, for example, were entered into. And as I say, the voiding of the order is, I think, going to have wide and unforeseen consequences. The duty is placed on the OR in these cases, and any appointed liquidator, to refer matters to the court. The bill has effect from the 27th of April 2020. It's not yet been brought into law, but the prospect of it and its terms have been considered in 3 cases. The first is Short Gardens, which was an application to restrain presentation based on liability orders. In this case, Mr. Justice Snowden held that, guided by counsel, held that he had to make the decision on the basis of the law as it stands. Certain cases were not cited to him, but I query, given the fact of that case, whether he would have restrained it in any event. Nonetheless, in the Travelodge case on the 6th of May 2020, Mr. Justice Briss considered 2 things. Firstly, a press release from the government dated 23rd of April 2020, in that it was said that the government will temporarily ban the use of statutory demands made between 1st of March 2020 and 30th of June 2020, and winding up petitions presented from 27th April through to 30th of June, where a company cannot pay its bills due to coronavirus. Solicitors for Travelodge also obtained an email from the civil servant saying that the intention was to protect high street shops and other companies against aggressive rent collection by landlords. This case involved Travelodge as against a landlord, so either that email was fact-specific or the scope of the bill was subsequently changed. In either event, following a Denning judgment, it was held that the court does not necessarily always have to make its decisions on the basis of the law as it stands, but can, in a proper case, take into account what the law may become. And the court could take into account imminent changes in the law. There was such a change, and Mr. Justice Briss granted an injunction. That means that de facto, creditors were able to obtain injunctions on the basis of the bill from the 6th of May 2020 onwards. 20th of May 2020 was the first draft of the bill. The intended retrospective effect was clearly set out. Rear Company, Mr. Justice Morgan, followed the Travelodge case. In certain circumstances and for certain purposes, the court can take into account reaching its decision, the possibility of a change in the law. Again, an interim injunction was granted. Of note, Mr. Justice Morgan held at this hearing that the current expectation is the bill will receive the royal assent by the end of June 2020, and he had a high degree of confidence that the relevant parts of the bill for this purposes would be enacted in more or less the current form. That, in my view, remains the case, and at a hearing last week, it was common ground between the parties and with the judge that this dicta remained good law, bearing in mind everything that had been said at the second reading of the House of Lords and in subsequent press releases. So the current position, sent to the House of Lords on the 3rd of June, 9th of June, second reading, 16th of June, committee stage, royal assent, query, but probably by the end of the month. So that means that this suspension will currently expire towards the end of July 2020, but there are already calls for an extension, and I note that the stay on possession proceedings now expires on the 30th of October, and in my view, the Travelodge decision in particular creates uncertainty. So in summation, to present a winding up petition, a creditor now needs a reasonable belief that the coronavirus condition is met. The court must determine at a preliminary hearing that it's likely that the coronavirus condition is met. The creditor then advertised, and there is a final hearing. Throughout this period, the company is able to trade as normal. If a creditor is unable to satisfy the coronavirus condition, the creditor could threaten a petition on the presentation date, that is to say, the day that the bill expires or when enacted, the measure expires, and a creditor could avoid an injunction founded on the bill by giving an undertaking not to present before that date. But in all these matters, future government announcements of changes or of extensions need to be given significant weight. That concludes my talk. I'll now hand over to Carly for Lisa Feng.
Thank you, Ian. That was great. I'm now delighted to introduce Lisa Feng. Lisa's practice covers a broad range of commercial and chancery litigation, including a specialism in insolvency. She continues to develop her practice in all aspects of personal and corporate insolvency, and frequently acts for both debtors and creditors in relation to disputed bankruptcy and winding up petitions. She also acts for office holders in relation to various claims under the Insolvency Act. Lisa is now going to be talking to us about termination clauses in supply contracts and how they are impacted by the bill. Thanks, Lisa.
Good morning, everyone. I'm going to be discussing termination clauses in supply contracts and how they have been further restricted by the bill. So, as you will have seen from Ian's talk earlier, that a common theme under the bill is to help struggling companies and, in essence, to give them more breathing space. And in fact, this was said to be expressly stated as giving companies breathing space and tools to maximise their chance of survival in guidance published on the 1st of June. So what's the problem here regarding termination clauses? Well, we're all aware that many contracts, in fact most contracts, will contain clauses which protect a party's position upon a counterparty's insolvency. So the clause may often state that there is a right to terminate, or even there is an automatic termination upon the counterparty's insolvency. A contract may also have other clauses which allows a contract to be terminated for events of default, for example, if a level of arrears have been reached. So the bill is intended to essentially have such clauses cease to operate upon a company's insolvency, so that termination clauses that engage on insolvency and which allows termination based on past breaches of contract will cease to have effect upon a company's insolvency. When do the protections arise? Well, at the moment, you may know that there are existing protections relating to insolvency-related clauses ceasing to have effect under sections 233 and 233A of the Insolvency Act. They essentially apply to services such as gas, utilities, electricity, and IT services, and are considered or defined as essential supplies under the Insolvency Act. The new provisions are intended to expand those existing protections and in fact, if you compare the provisions, offer much wider protection. They apply to all contracts for the supply of goods and services. A new section 233B and 233C of the Act will be introduced. It is triggered when a company becomes subject to a relevant insolvency procedure, and they include the typical administrations, liquidations, CVAs, when an administrative receiver is appointed, and also the new style moratorium introduced by Part A1 of the bill. So what is prohibited under the new protections? Well, there are three main strands to the prohibition. The first is to deal with actual clauses in a contract. So there will be a prohibition, or clauses will cease to have effect where the clause entitles a supplier to terminate or do any other thing in relation to their supply when the company enters into the relevant insolvency procedure. You'll note that it will apply to both automatic clauses where the contract is automatically rendered terminated, or in relation to optional termination clauses where you will have an option to end a contract. It also encapsulates any other thing. In other words, it's potentially very wide. It could cover any terms of the contract which effectively changes the party's obligations upon insolvency. So that could be if a contract provides upon insolvency there would be a different level of interest, a different level of charges, or certain charges which may apply. It is intended, it seems, to be extremely wide in coverage. The second prohibition relates to the prohibition on termination based upon breaches which occurred before the start of the insolvency period and where the entitlement to terminate arises before the start. So, as I mentioned earlier, frequently contracts will not only have termination clauses based upon the insolvency of a company, but there will be also other clauses which allow a supplier to terminate based on other grounds, for example, a certain level of arrears or other defaults arising. So the second prohibition is intended to address those clauses where certain level of arrears may have arisen prior to the insolvency event, and the entitlement to terminate arose before the start of the insolvency period. In essence, practically speaking, suppliers will have to be on the ball in relation to any breaches. As I'll flag up later, this may well have an effect of suppliers being less forgiving on certain defaults and arrears building up, because if a company were to go into an insolvent procedure, the clause will cease to have effect. The final main strand of prohibition introduced by the bill is that a supplier cannot demand payment of outstanding pre-insolvency charges as a condition of continuing supply. So at this stage, if a company enters into insolvency, a supplier cannot turn around and say, well, you need to pay off your existing arrears before we continue to carry on supply. That's aside from any ceasing of contractual terms in a contract as per the first and second prohibitions. This simply relates to what a supplier cannot now demand upon a company entering into insolvency, regardless of what other conditions may or may not exist in a contract. So how long do the prohibitions last? Well, the prohibitions are intended to help a company, and there is it's intended to give a breathing space for the company, with the idea that the company may ultimately be rescued. In practice, whether or not this will ultimately assist will obviously remains to be seen, but certainly in the explanatory notes it is suggested that the idea is to maximize the rescue opportunities for rescuing the company or the sale of the business as a going concern. It will cease to have effect when the company essentially is out of the formal insolvency procedure. So, for example, the end of the New Style moratorium or the end of an administration. So it all looks pretty grim for a supplier so far. What are the options if you're a supplier? Well, first of all, if a company has entered into administration, liquidation, or administrative receiver has been appointed, the supplier can liaise with the office holder and try and seek consent to terminate its supply. In any other case, consent may be sought from the directors of the company. or you can apply to the court on grounds of exceptional hardship. Now, this is an interesting limb introduced as one of the main remedies that essentially a supplier can consider. There is little guidance as to what is meant by hardship. The only guidance, by way of a practical example published on the 1st of June, is where it's referred to the supplier's own solvency may be in difficulties. Other than that, there are no definitions in the Act itself as to what is hardship. It is noted, of course, that it doesn't refer to exceptional hardship, it's just hardship. So a supplier may consider, well, what are the impacts on cash flow, on continuing to supply with the risk of the company not paying, and whether it will have an impact on its own insolvency. The supplier will have to weigh that against, obviously, the costs of applying to the court and having a determination from the court on this issue. And finally, it's implicit from the existing legislation I've gone over so far that a supplier can still terminate based on events occurring after the insolvency procedure. So if there are fresh arrears arising following on from liquidation or administration, the supplier does have a right to terminate based upon those fresh arrears. So stepping back for a moment then, what is the ultimate practical position the supplier is in at this stage? Well, insofar as administrations are concerned, it seems that a supplier may well be able to claim the costs of supply as an expense of the administration. Where a company is in liquidation, the liquidator may well give consent because the company is unlikely to be trading any further as a going concern. Perhaps when a company is in CVA, the position may well be more complicated, but one would have envisaged that a CVA would perhaps make provisions for how the company may meet its ongoing obligations. So practically speaking, it's not the end of the world for a supplier. There are protections within the Act itself which will protect the supplier's position, and in particular the last resort of applying to the court on grounds of exceptional hardship. But it seems that certainly in the case of administrations and liquidations, ultimately it may only have limited impact on what a supplier may or may not do in those circumstances. Will there be exempt suppliers? Yes, there will be permanent exemptions. As I've mentioned earlier, there are already provisions in the Insolvency Act dealing with essential supplies, which include utilities, communications, and IT service providers. Those are already provided for in sections 233 and 233A of the Insolvency Act and will continue to apply in respect of those supplies. But there are further permanent exemptions in respect of a long list of supplies that are listed in a new Schedule 4ZZA of the Insolvency Act. They include certain financial institutions, various financial and capital market contracts. Critically, it ought to be noted that there is no obligation to continue to supply finance to companies in a relevant insolvency procedure. So lending contracts are essentially exempt from the need to continue supply. And that's expressly provided in the new Schedule 4ZZA of the Insolvency Act. There will also be temporary exclusions applicable for small suppliers. That will only apply as a temporary provision, however, until 1 month after the provisions come into force. The small suppliers under the Act will need 2 of the following conditions: turnover not exceeding 10.2 million, balance sheet not exceeding 5.1 million, and or no more than 50 employees in their most recent financial year. So there will be exemptions for small suppliers. But as I mentioned earlier, one final last resort for a supplier is always to apply to the court on grounds of hardship, and that application may well be more relevant in the context of small suppliers once the temporary exclusion has expired. So final thoughts then in terms of practical implications of the protections. As flagged up already, it may be that given the limited options available on a company entering insolvency, suppliers may seek to protect their position at an earlier stage. Frequently, we'll have correspondence as between a supplier and a company negotiating, for example, payment terms or a payment plan dealing with arrears. It might be that under these new provisions, suppliers may need to be more careful as to how forgiving they will be of any defaults. It's, I suppose, often difficult for a supplier to really understand the true financial position of a company that they're dealing with. But if a company is unable to pay existing arrears, the risk is that if, say, a payment plan is reached and a default is waived as a means of terminating a contract, you may lose that right to terminate altogether if that buyer subsequently enters into a formal insolvency procedure. So suppliers may well need to consider more carefully as to whether they will waive any defaults or even seek to give more time to pay. Well, are there ways to perhaps draft a contract around the provisions? There is certainly no way to contract out of those provisions. However, one might consider, for example, whether it's possible to draft a material adverse change clause in a similar manner to contracts for sale of businesses. You might have a clause which says, a supplier may terminate if there is a reasonable ground to believe there's been a material adverse change in a buyer circumstance. I suspect if that provision were to be commonly used, there may well be further disputes around whether it's possible. It certainly goes against the spirit of the legislation, but it's perhaps an idea if one were to draft new contracts for supply. I've already flagged up to an extent when a court might intervene on grounds of hardship on a supplier. This area is likely to be a ground for litigation in due course. There is no definition, and as I say, it's arguable that in any case where there are cash flow issues regarding a supplier, their own solvency might be affected. So suppliers may seek to protect their position in this way. So that concludes my summary of the main provisions of the termination clauses to be introduced by the Act. I'll now hand back over to Carly.
Thank you, Lisa. So that really is the conclusion of the analysis as part of this conference of the specific individual changes that are made by the bill. We now have a session involving some high-level analysis of the bill, taking into account the overall view of the changes that the bill will bring to the insolvency landscape. I'm delighted to introduce two speakers on this topic. You'll be hearing secondly from Tom Longstaff. Tom was called to the bar in 2017, but prior to that was in practice as a solicitor in a Magic Circle law firm. His practice focuses on commercial and insolvency law, and as well as being regularly instructed to appear in the Winding Up list on behalf of both creditors and debtors, Tom has considerable experience of appearing in a range of hearings relating to personal and corporate insolvency. But first we'll be hearing from a man who needs no introduction really. Mark Cawson, Queen's Counsel, was called to the bar in 1982 and took silk in 2001. As is probably well known to you, he's recognised as a Band 1 leading silk in Chambers and Partners in the field of insolvency restructuring, regularly appears in the Court of Appeal on insolvency matters in any given year, will be noted to have acted in many of the high-profile insolvencies that we read about in the professional press. Mark also sits as a Deputy High Court Judge, and so helpfully for us can offer a perspective from both the bar and the bench. Mark, thanks very much.
Yeah, I'm just going to get the slides on the screen and then I shall make a start. Okay, well, good morning. As Carly said, I was called to the bar in 1982, which of course means that I was called before the Insolvency Act of 1986 came into force. And what I've seen during the course of my career is a massive change and a shift between a concern for the interests of the creditor, which is the primary concern of the courts when I first started, to a move towards concern towards the debtor as the rescue culture has developed. And that's in contrast to the United States, which has always had a much more generous approach towards debtors, with traditionally a regime of debtors being in possession of an insolvency process, which is something which we see introduced by the present bill. So historically, when I first started, there was talk about a rescue culture, to introducing a rescue culture, and that's something that was recommended by the Cork report. Something was recommended by the Cork report. The Cork report made a number of recommendations which were implemented in the Insolvency Act 1986, with the introduction of the regime, the administration regime, and the corporate company voluntary arrangement regime, providing an alternative to winding up. Matters developed then with the Insolvency Act 2000, introducing the then very limited moratorium that was introduced in relation to company voluntary arrangements by the new Section 1A of the 1986 Act, and then the Enterprise Act 2002, under which provision is made that a qualifying floating charge holder can no longer appoint an administrative receiver, which was of course a very powerful power that a qualifying floating charger held prior to that, restricted to going through the administration regime. And this bill must be seen as the next step in the rescue culture, developing the rescue culture. And as you will have heard from the various talks on the various individual provisions of the bill, a bill that's, when enacted, will make very significant changes to the law. And in particular, perhaps the most fundamental point, the introduction of the concept into English law of the debtor in possession, an insolvency regime in which the company itself retains control without an office holder being appointed. The monitor under the moratorium regime, for example, having a much lesser role than an office holder in an administration or liquidation. Now, of course, this legislation is being introduced in haste against the background of the coronavirus crisis. But of course, it does introduce fairly fundamental changes to the law, and introducing them rather quicker than anticipated. I'm just going to slip over that slide to this one, and just something of a reminder, a recap on the key elements of the bill. I'm making the point that the moratorium, the arrangement and reconstruction plan, the restriction on termination clauses, these were all planned in the sense that legislation was going to come forward at some point to deal with these various issues. But because of the coronavirus crisis, rushed up the list to get onto the statute book, but being done in something of a hurry, which is frankly a matter of some concern so far as the future is concerned, and how matters are going to be dealt with. And of course, whilst these are permanent changes, there are then the temporary provisions which temper the effect of these more permanent provisions. For example, under the moratorium regime, the ability to a company to introduce a moratorium to make it by way of an out-of-court appointment, even though there might be a winding up petition, something that exists under the during the coronavirus crisis, but will not succeed, not survive that. And then two further temporary changes, which you've heard about, the ban on statutory demands and winding up proceedings, and the temporary suspension of liability for wrongful trading. So that's the background which you've heard a considerable amount about. As other speakers have mentioned, the bill was dealt with in committee stage in the House of Lords on the 16th and 17th of June. That's yesterday and the day before. It's due to go back for report stage and third reading on the 23rd. I think that's Tuesday of next week. The debate is informative in highlighting, I think, some of the issues that are going to come to the fore as the Act does come into force, as it inevitably will towards the end of this month. Concerns particularly expressed as to this balance between the rights of creditors and debtors, and whether one isn't perhaps going too far towards the position of the debtors. and the impact on employees and pension rights being a matter of additional concern. Baroness Neville Rolfe, for example, said, "I support these measures, but they change the balance of corporate law and can make life difficult for lenders and investors that business need for success." And this must be a concern, that under the new regime, lenders will be put off lending, particularly through the device of the qualifying floating charge. And Lord Hendy's comments, there can be no doubt that the opportunities offered by the bill, generally welcome, will be utilised, as in Chapter 11 proceedings in the USA, to scrap jobs, cut pay and dump pension liabilities. This is a concern. During the course of the debate, considerable concern was expressed about the use of pre-packs in administration, and in particular the absence of a mandatory requirement to refer pre-packs to the pre-pack panel, as had been a recommendation. But the government did make it quite clear that certainly during the course of the coronavirus crisis, there is no immediate plan to introduce legislation that will make it mandatory to refer pre-packs to the pre-pack panel. The concern being that that will inhibit administrations and what administrations are supposed to achieve. A concern about the rushing through of this legislation is that it's not had the scrutiny that it would ordinarily have. And certainly there are elements of uncertainty about it, which are going to, I think, take up a great deal of time with the courts. Certainly during the course of Tuesday's discussion of the bill in committee, Lord Thomas, the former Lord Chief Justice, queried whether, looking at the provisions of the Act, for example, whether a financial services creditor with super priority under a moratorium has a claim on assets subject to charge debts without super priority. Now, if there are fundamental concerns about certainty in relation to aspects such as that, one can see that there is potentially a considerable amount of litigation as the provisions of the bill and the Act are worked out. However, despite voluminous amendments tabled, it's unlikely that there will be any sufficient amendments that will survive the parliamentary process. So, moving on to look briefly in the time that's available to me at the regimes and the impact on the regimes, I'm going to look at moratorium, and I'm going to look at the Part 26A schemes, and then Tom's going to take over at that point and deal with the other aspects of the bill. But looking at moratoriums, first of all, first thing I think to just reflect on are the routes out of moratorium and the likely routes out of moratorium. Recovery, perhaps with new finance introduced into the company, having been given the breathing space available through a moratorium. Sale and refinancing outside insolvency, where one manages to get a sale away and refinancing outside insolvency. A CVA, but noting that a CVA can't bind a qualifying floating charge holder or a preferential creditor. A scheme under the new Part 26, a scheme under the old Part 26, which might be a feasible way out of a moratorium, or implementing a restructuring plan under the new Part 26A of the Act. Essentially, if one is considering a moratorium and satisfying the likely test that I'm going to come on and briefly discuss in a moment, then in essence, you're going to be looking at one of those 5 options and considering it likely that one of those 5 options is going to occur. The last 2 of those routes out of moratorium, administration and liquidation, are of course a reflection on failure. So when is a moratorium, let's look at this, when is a moratorium most likely to be of benefit? As I see it, it's most likely to be in a situation where one's got a company with accrued unpaid liabilities, is under pressure from creditors, but does have sufficient cash to pay creditors day to day during the moratorium. That really is the key to the moratorium and success through a moratorium, this ability to be able to trade on a day-to-day basis through the moratorium. And so it really lends itself essentially to resilient companies under financial pressure due to the COVID-19 crisis or otherwise. And one perhaps can see smaller companies more likely to benefit than larger employment-heavy companies with a significant payroll. So just touching on what I see as a few controversial areas in relation to moratorium. Firstly, the test, likely that moratorium would result in rescue of the company. Likely, I think, as other speakers have suggested, is likely to be the same test as previously been the case in relation to administration, not likely in the sense of more likely than not, but a reasonable real prospect of success test. Would, the word used in the statute, there was an attempt to introduce an amendment to substitute that with could, which would seriously weaken the test, but the government held out on that and would remains the test. And then of the company, it is in relation to the company. It's the survival of the company that needs to be what is likely, not something else. In contrast to, of course, administration, where administration can be a useful tool to rescue the underlying business of the company through a pre-pack. Of course, there is the qualification during the course of the coronavirus crisis that the likelihood test may be satisfied, as those additional words, or would do so if it were not for any worsening of the financial position of the company for reasons relating to coronavirus. That, I think, poses a number of problems. This perhaps isn't quite the forum to go into them in huge detail, but what one can see some degree of uncertainty as to what that might mean in the circumstances of this legislation. The role of the monitor there's obviously a degree of uncertainty as to what exactly the duties of the monitor are going to be. This sort of hybrid position between an office holder and someone having this supervisory role. The Insolvency Service issued some draft guidance the other day on this, which is certainly well worth reading. And there is an article on our website by Giles Maynard Connor and Jodie Woodridge commenting on that guidance, which I'd encourage you to have a look at. There are issues in relation to the length of the moratorium. The Law Society, for example, has made the point that that it is not entirely desirable for the moratorium to potentially continue for as long as it might potentially continue for. I think there are some real issues in relation to super priority of moratorium debts that will be available in circumstances where there is an administration or where there's a winding up within 12 weeks of the end of the moratorium. In those circumstances, moratorium creditors and some pre-moratorium creditors for whom a payment holiday wasn't enjoyed during the course of the moratorium will have super priority. I've already highlighted the difficulty identified by Lord Thomas in relation to that, but there are others. There is scope, for example, for creditors to game as to the timing of particular liabilities, for example, and the role of banks. So I see a multitude of issues in relation to how exactly this super priority is going to work in practice. The position of secured creditors, and particularly the qualifying floating charge holder. Of course, a qualifying floating charge holder cannot block a moratorium, and it cannot, security cannot now provide that floating charges should crystallise in consequence of a company entering into a moratorium, which certainly does significantly reduce the powers available to the holder of a qualifying floating charge, reducing them significantly further than the reforms introduced by the Enterprise Act 2002. And this must, as I say, raise real concerns as to lending and whether lending that might in the past have been available will be available in the future. Crown debts. The Finance Bill, as you may well be aware, is proposing to reintroduce certain preferential debts again. And the feeling is that that might be a considerable impediment to the success of a moratorium. So far as challenges are concerned, you'll have heard that the monitor's actions and the director's actions are open to challenge by creditors, members and other persons affected. There is an unfairly harmed test. It may well be that much the same sort of test is applied as is applied at the moment to challenges to the conduct of administrators and what administrators do in relation to the conduct of a company's business. But one can see that it's going to be a much more complicated exercise, bearing in mind the conflicting rights that are going to emerge and conflicting priorities that are going to emerge during the course of a moratorium. So in short, I'd say that my feeling is the courts are going to be very busy with a number of issues that are going to arise, issues that perhaps would not have arisen had there been more time to take this legislation through Parliament and for these issues to be gone through, and had there been an opportunity for greater consultation before bringing into effect these reforms. I'm going to go on now and deal just briefly with arrangements and reconstructions for companies in financial difficulties. This is the new Part 26A of the Companies Act 2006, which introduces a United Kingdom equivalent of the US Chapter 11 plan, where there is an arrangement with members and creditors, but in circumstances where it is possible to cram down the rights of certain creditors or indeed members in certain situations. The procedure, as you will have heard, is very similar to that of the existing Part 26 in relation to schemes without the cram down facility. One prepares the plan documents, there's a convening hearing before the court where the courts make sure that all parties are properly represented. There are then plan meetings where there is a vote on the various proposals, and then a final hearing, a sanction hearing, at which the court sanctions or otherwise the scheme. And the two cram down mechanisms of firstly there being identifying somebody or a class with no genuine economic interest. If that can be demonstrated, then they're not going to be heard in relation to the scheme. Alternatively, there's the ability to cram down dissenting creditors by the application of a no worse off test, comparing the position of the creditors or members in the circumstances of the scheme as against other alternatives that might be available. Provided that, even if they don't give the consent, there is consent by a class that is in the money, as it is put. So again, the scheme is going to raise considerable issues for the court as it works its way through this new legislation. I think it is likely to apply many of the same principles that applied to Part 26 schemes, but just bear in mind additional requirements that are going to have to be made out. There are various distressed company financial conditions to entry that are required to be met. The court is going to have to consider whether the classes are properly constituted, which could raise fundamental issues. It may be necessary to identify the relative alternative if it is being suggested that a creditor or member is no worse off. And then having identified that alternative, it's going to be necessary to consider whether in fact, having had a look at that alternative, that creditor or member is worse off. And that's going to require potentially evidence and valuation evidence comparing the various alternatives that might be available. A similar exercise in relation to considering whether a creditor or member has a genuine economic interest. And bearing in mind that at the end of the day, the company has a discretion and is concerned as to whether, looking at it as a whole, the scheme is just and equitable, fair and equitable in the circumstances. So just a few considerations which I would just touch on before concluding my particular slot. First question, could the relevant alternative, when considering whether a member or creditor is worse off, could it be an alternative scheme? My own view is probably not. That just doesn't seem to fit in with the legislation. A scheme is put forward, and it's a question of comparing that with the other alternatives available. But there is scope for argument in relation to that. The 75% threshold is a high threshold, as it is with company voluntary arrangements. In the US, such a majority is not required. Will that limit the availability of schemes? Possibly so. Note also that, that where there are moratorium super priority creditors, then they are in an effective position to veto the scheme to the extent the scheme seeks to make provision for them and to limit their ability to rely upon their super priority rights, which may be a fetter if one is seeking to move from moratorium into one of these schemes. And finally conclude by saying that although the traditional Part 26 schemes have generally been reserved for larger companies and have been a considerable attraction because the jurisdiction applies to any company that might be wound up in this jurisdiction, even though not actually incorporated in this jurisdiction. And it has tended to be larger companies that have made this available. It is certainly worth considering Part 26 schemes in relation to SMEs and smaller companies as a cheaper alternative to pre-pack administration in particular circumstances. And certainly that is something that I personally would like to try and encourage and see whether that can be achieved. Well, that concludes my slot, and I'm now going to hand over to Tom Longstaff.
Yes, thank you, Mark, and good afternoon. So this second part of the talk will provide a high-level overview of the changes to termination clauses, statutory demands and winding up petitions, and wrongful trading, along with some thoughts as to what we think is the key impact of these changes. So firstly, termination clauses. We will all be familiar with clauses in supply contracts which enable a supplier to cease supplying goods or services to a company on an insolvency event. And that is a fairly well-established principle of contracts law. And as Lord Mann said in Belmont Park Investments, there is nothing objectionable or evasive about a provision entitling one party to terminate if the other becomes bankrupt. And certainly up until now, there was nothing objectionable about that proposition. However, the introduction of a new Section 233B into the Insolvency Act seeks to enhance, we think, the existing essential suppliers regime under Sections 233 and 233A by imposing a ban on such clauses, subject to limited exceptions. And the aim, of course, is to preserve the supply of goods and services to a company subject to an insolvency procedure. And on the face of it, this, we think, has the potential to create a potentially unfair situation whereby smaller companies are obliged to continue to supply larger companies without necessarily being paid, or where there are substantial pre-insolvency arrears. And whilst there is a temporary exclusion for small companies during the COVID-19 pandemic under Section 13, that is first subject to the small company being able to satisfy subsections 4 to 10, i.e. to establish that the supply company is a small company. And secondly, the second condition is that the debtor company becomes subject to a relevant insolvency procedure during the relevant period. There are one or two further exclusions, which I will briefly summarise. Firstly, Section 12 subsection 5 of the bill provides that the supplier may nonetheless terminate the contract if, firstly, the relevant office holder consents, B, if the company consents, or if the court is satisfied that the continuation of the contract is likely to cause hardship. And we think that the last part of the test and the requirement to show hardship is likely to require further refinement by the courts. And in particular, that courts are going to have to develop principles and factors which will be applied when deciding whether or not a supply company can meet the criteria of showing hardship. And on one view, that may not be particularly difficult to establish because of the fact that a supply company is essentially having to continue to supply goods and services to an essentially insolvent company without there being any form of guarantee that they will be paid for providing those services. And
sorry, can I just interrupt for a second to invite you to just pop your slides up onto and to share the screen, because I don't think our participants can see them at the moment.
Oh, you should be able to see them now. There are further exclusions in sections 233B and Schedule 4 ZZA, which provides for exclusions to financial service entities, including insurers, banks and other types of payment institutions. And controversially, both Section 233B and Schedule 4 ZZA can be amended by the Secretary of State using a statutory instrument. And that in particular has attracted some controversy in the debates in both the House of Commons and the House of Lords because of the effective bypassing of Parliament to effect what are significant changes and are certainly political changes as well. So these changes, of course, are new to this jurisdiction. They may even be controversial. However, what these changes also represent is an alignment with other jurisdictions. Of course, Chapter 11 has focused heavily in the talk so far. These changes are consistent with Chapter 11 principles, and also it's something with both South Korean origin and something which is also seen in Australia. So it remains to be seen whether these are welcome changes or if this will potentially cause more problems than it solves, particularly for suppliers who may already be in difficulty themselves. And the next change, of course, perhaps the most significant and controversial change, is the temporary ban on statutory demands and winding up petitions. And this was, of course, eagerly awaited. It was foreshadowed by statements from both the UK Business Secretary and the Communities Secretary, Robert Jenrick, who said that the government would do everything they can to ensure that commercial tenants were well protected. And those statements provided some assurances to the High Street. And I was instructed in one particular case whereby a statutory demand was being defended on the basis of there being pending legislation. But of course, at the time those ministerial statements were announced, it wasn't known what the scope of the bill would be, or indeed if of course it would be released at all. And one such case, which was decided before the Vice-Chancellor, the case of Reshort Gardens, before the release of the bill, in dismissing an application to restrain presentation of a winding up petition, the Vice-Chancellor said that it seems overwhelmingly likely that the proposed legislation will be limited to companies in certain identified sectors of economic activity, and to relate to statutory demand petitions based upon claims by landlords for arrears of rent. And based on the ministerial statements released before the bill, that certainly did seem likely. However, it's of course now well known that these are extremely broad measures which apply to any sector of business rather than being confined to the commercial tenant sector. And very briefly, of course, Ian has already explored these provisions in detail. Paragraph 1 prevents a creditor from presenting a winding up petition on the basis that a company has failed to satisfy statutory demand. Paragraph 2 prevents a creditor from presenting a winding up petition unless it can be demonstrated, or rather, unless there are reasonable grounds for believing that COVID-19 has not had a financial effect on the company, or the debtor company would have been unable to pay its debts, even if it hadn't been adversely affected by COVID-19. And as Ian pointed out, paragraph 4 provides that winding up orders made in the relevant period will be void if the orders were not one that would have been made had the court applied the provisions of the bill. And we've seen in at least 2 cases how applicants have relied on the provisions of the bill in seeking an injunction to restrain presentation or advertisement of a winding up petition, firstly in Travelodge, which predated the bill, and the case of Ria Company before Mr. Justice Morgan, which postdated the release of the bill. And a further significant change, and one which we think is particularly controversial, is the alteration to the commencement of winding up for the purposes of the Act. Paragraph 9 of Schedule 10 provides that the winding up is deemed to commence on the making of a winding up order rather than the date on which the petition was presented. And that has the effect of eliminating the effect of Section 127 of the Insolvency Act, which would normally be, of course, to void any dispositions of the company's property made between the presentation of the petition and the date of the winding up. And so the impact, of course, paragraph 1 introduces a blanket prohibition of statutory demands. I've already been instructed in a number of cases in which we have deployed that particular provision of the bill. Paragraph 2 is a qualified prohibition, which is likely to demonstrate significant dispute. And we think that the disputes are likely to focus on the second limb of the test, namely whether the debtor would have been unable to pay its debts, even if COVID-19 had not had a financial effect on the company. And many questions will arise from that. For example, what of the company which experienced financial difficulty before the pandemic and was unable to recover because of it? But at the same time, there is likely to be creditor uncertainty. We think there will be far less use of the statutory demand and winding up petition procedure, and an increase in use of the Part 7 procedure through litigation rather than an insolvency process, and or a likely increase, we think, in applications to place a company into administration. And that is one of the things which we think would be useful to discuss with insolvency practitioners as a potential alternative. And the changes to the commencement of winding up, of course, facilitates trading post winding up petition. It removes the important creditor protection to creditors, of course, when the assets of the company are under the control of directors. And the purpose of Section 127 is, of course, to ensure parity between the creditor group. And arguably, that protection is still needed despite these changes, because under the provisions of the bill, a winding up petition can only be presented against a company that wasn't viable before the pandemic. So one would question the rationale for this particular change. If this change wasn't implemented, for example, that wouldn't undermine, we don't think, the rescue culture which Mark alluded to at the start of his talk. These changes are, of course, mitigated by the introduction of look-back periods in paragraphs 10 to 18, and the extension of up to 2.5 years in the case of transactions at an undervalue and preferences. Finally, a high-level overview of the changes to wrongful trading, again foreshadowed by ministerial statements and some optimism from the Chief UK Policy Director of the CBI. The changes apply retrospectively. I don't think that the provisions can be fairly described as a suspension, because instead what is essentially created is an assumption that during the relevant period, the director is not responsible for the worsening of the financial position of the company. And the reason for that is in paragraph 10, it said, the court is to assume that the person is not responsible for any worsening of the financial position of the company or its creditors that occurs during the relevant period. So there is no outright removal of personal liability for wrongful trading. Directors will, for example, still need to take decisions in the best interests of the company and its creditors, including by deciding whether or not to place the company into liquidation or administration. And so this is therefore a reduction of liability rather than an outright removal. There is no impact on pre-existing liability for wrongful trading, nor is there any impact on common law breach of duty claims, fraudulent trading, or the disqualification procedure under the 86 Act. And so therefore, in my view, directors should be cautious about these changes. And I say with good reason, they certainly should be advised to be cautious and not see this as a blanket removal of liability. So just some concluding thoughts. Undoubtedly, these are significant changes to the insolvency landscape. The rescue culture still prevails, which Mark alluded to at the very start, continues to be a feature of English insolvency law. And what we have here are a range of additional provisions which can be utilised by insolvency practitioners and solicitors to protect businesses. And there are, of course, a number of tools for litigators to deploy. A number of the changes here are likely to become battlegrounds in insolvency litigation, and it will be interesting to see how the courts shape insolvency law and how they interpret some of the changes. And that's not least because some of the aspects of the bill are unusual, in particular the retrospective effects of the wrongful trading provisions, the blanket prohibition on statutory demands, which are features we think are particularly unusual. But the context of these changes is likely to be at the forefront of the court's mind. Of course, they are introduced along with a variety of measures by the government to protect jobs and businesses. That's at the forefront of the bill, and we expect the court will have regard to that objective when interpreting these changes. So that brings an end to this talk, and I'll now pass back to Carly.
Thanks very much, Tom. I'm now going to introduce our final speaker. Our final speaker is John Tribe. John is a senior lecturer in law at Liverpool University, and several years ago now we were delighted to have him join Chambers as an academic associate. John's research interests are insolvency law, bankruptcy history and equity and trusts, and he is the joint author of Muir Hunter on Personal Insolvency, as we all know, the leading textbook on personal insolvency and bankruptcy. We welcome John now, who is going to give us an academic perspective on the bill. Thanks, John.
Thanks very much, Carly. Hopefully you can see my screen and my slides. My function today really is to give a kind of high-level view of how the reforms sit in the insolvency landscape generally, and I'd like to do that in two parts. So I won't dwell too much on the minutiae. Members of Chambers have already dealt with things like wrongful trading and the idea of, as you've just heard from Tom Longstaff, the continued existence of other directors' duties. Similarly, Steve Fennell and Neil Landsberg and Mills also touched on that. And despite Carly's introduction there with Muir Hunter, I won't mull on the complete lack of personal insolvency provisions that we've seen, at a point that was also mulled on by Lord Stevenson and Baroness Bowles in the House of Lords during the debate stages. But I will pick up on some small elements of the reform, particularly charities and where they sit in the insolvency landscape generally. So first then, what I want to do is go a bit macro, briefly to set the scene where we might see these insolvency reforms. And to do that, I want to use Friedrich Nietzsche, who you can see here pictured on the slide. He was also on the first slide. And in particular, it's an idea that he first suggested in his work in the 19th century, although he's a German philosopher who mulled on a number of things. But one of those was, of course, eternal recurrence. And I want to introduce the idea of what I'm calling insolvency eternal recurrence within the process of reform, and in particular insolvency reform. And this is taken from this work. So it's the Gay Science from 1882, and it's this red text that is the seed corn of this idea. So this life as you now live it and have lived it, you will have to live once again and innumerable times again, and there will be nothing new in it. But every pain and every joy and every thought and sigh and everything unspeakably small or great in your life must return to you. But of course, Nietzsche's talking about the broad sense of our lives as we've lived them, as opposed to insolvency reform. So as I say on this slide, there's a disparity between Nietzsche describing time as infinite, whereas we're just existing in this insolvency law mini blip. But we can bring him back down to the minutiae by perhaps focusing on what I've called on this slide, the ages of insolvency. And in particular, there are, of course, ages of reform or ages of process of movement, as we've seen throughout our insolvency history, the way in which ideas have balanced against each other. Mark mentioned this in his introduction, Mark Cawson QC, when he was talking about, of course, the debtor or creditor-friendly nature of different jurisdictions when he was reflecting on his entry to the bar in 1982. So here you can see in the green column on our ages of bankruptcy slide, relatively early bankruptcy. So what we might call the age, or what I've called the age of discharge. So that's largely bankruptcy available for traders that has as key feature relief and rehabilitation. So perhaps some themes or ideas of rescue there. Then we move to officialism, that big blue chunk of the slide. And that's, of course, the advent of the insolvency service, as it now is, and then a movement perhaps away from creditor control to official control. But perhaps most importantly for today in the recent CIG bill, of course, is that yellow column that you have there. And that is, of course, what we could call the age of cork, or indeed even the Corkian age. So that's to say the environment, the insolvency history time period that we now sit in, and which we would say begins in the 70s with the work of the Cork Report and then eventually Command Paper 8558 and the process, as Mark has suggested, of the beginning of the rescue culture. So during that process, or during that Corkian age, to what extent have we seen, or is there evidence of insolvency internal recurrence, this idea of themes coming again before policy makers and then the legislature that reflect the same kinds of ideas? For example, rescue or some kind of director-friendly movement in reform. And of course, this is particularly important when you consider the idea that whilst the Cork Report was being drafted and the committee were working, they, of course, were heavily influenced, as Carruthers and Halliday have shown us, by other insolvency reform activity occurring in the 70s, of course, Chapter 11 reform. So one argument that we might deploy is that there's insolvency eternal recurrence of reform ideas that are cyclical and come again and again, or we might say that this point that we find ourselves in now, this CIG bill, is the natural consequence of that which commenced in the 1970s, that this is this introduction of cram down, the moratorium and other elements that have Chapter 11 like qualities are, of course, the end game of the process that was commenced by 8558 in 1982, and then, of course, the 86 Act. So is it policy making on the Penrose stairs? Are we having cyclical activity, or in fact are we seeing novelty? Over the last 2 days, a number of members of chambers have commented or reflected on the various reform mechanisms that have come to pass. And of course, as you can see here in the first 4 bullet points anyway on the slide, that perhaps this plus a change title or My Emperor's New Clothes picture is justified, in the sense that you see here, Carly was reflecting on the idea that there's a resemblance between administration's moratorium and the new moratorium in terms of the derivation of the moratorium regime. Paul Stanley, one of the participants in an earlier session, asked a question around whether or not we're seeing a rehash of the CVA reforms that led to the 2000, Insolvency Act 2000 reforms. And Carly responded by reference to that, and also, of course, the 2018 reforms that, as we know, have been long consulted on and now have been segued in, perhaps, in this emergency period. And then Lisa mulled on the idea of the familiarity that some of you, or many of you, will note between administration and then some of the restrictions on enforcement. And then finally, and perhaps most importantly for this eternal recurrence thesis that we're testing, were some of David's points around the Part 26 regime as was, so schemes of arrangement, and then the new Part 26A schemes, albeit, of course, with some of those extra American Chapter 11-like additions. Nevertheless, as David pointed out, though, we're seeing an extensive body of authority and experience on schemes of arrangement that can be, as the policy documents show, transmitted into our thoughts about this new procedure. So is it new, or is it something, of course, that we're familiar with that's had some perfection that, again, as I say, is the natural end game of what commenced in 1982? I'll touch on the final 2 points in my second part of my treatment, which takes me to part B of our discussions, which I'll just go through here. And this is a bit of a focus on the debate stages. Just want to make 2 main points really here. Of course, the quality of the debates varied, as you'll have seen, between the 2 houses. It's a shame that we had things like maiden speeches that were interjected whilst important insolvency issues needed to be debated properly and constituency related issues that were raised, when perhaps it would be better to focus on the minutiae. But there were some interesting points, of course, made, most notably, I'd argue, in the House of Lords, where we have a focus on the idea that perhaps Parliament shouldn't have continued to be on holiday in Easter. Perhaps we should have had an emergency legislation that was much smaller and focused just on the temporary measures that colleagues have referred to, instead of segueing in those wider reforms that were first generated or reported on in 2018. Similarly, in terms of the scrutiny, we saw that in the House of Commons there was only 47 minutes of debate. Is this satisfactory when we're thinking about such fundamental changes potentially in our area? But the main point I want to make in this second part is this. Some of you will remember that when the Company Law Review Steering Group first reported, which of course then led to the Companies Act 2006, moratoria were discussed in the context of schemes of arrangement. So we know that they became a restructuring frequently, as I've referred to David's comments, and that there might be a way to facilitate their use within an insolvency or an ex ante insolvency sense by introducing moratorium. This was specifically siloed by the Company Law Review Steering Group. So when, for example, Lord Hodgson reflected in this current bill on his part in the 2006 Act and the part he played there, we might lament that, in fact, they did exclude moratoria back then, because of course we wouldn't be finding ourselves in the position we're in. Perhaps the main point, though, on that kind of regulatory gap is that we don't want to find ourselves potentially in this same retrospective hindsight position again, because as both Baroness Annalay and Baroness Barker pointed out, there is currently no provision for insolvent charities in the passage of the bill and its provisions, its clauses, which is of course deeply problematic when we consider the public benefit functions that charities fulfill or have to fulfill because of their statutory makeup, but also with the way in which we think about the rescue culture and how that operates, and how, if any entity is going to be rescued for public benefit aims in a communitarianism sense, it should probably be charities. So the fact that they're not included, save for in the meetings point that Harriet made reference to yesterday, it is lamentable, or at least problematic, you might argue. Is it again another example of regulatory lag? So the other point I wanted to raise in relation to the bill is this, and it's the stakeholder point. So Mark referred to the shift and balance between debtor and creditor interests over time, those power relationships that we see here. I've used Mark as a representation of that power, underlying power that we see playing out within insolvency. And of course, we saw in the debates in the Lords anyway, the presence of R3, and particularly Lord Hope, of course, sometime Supreme Court Justice, Lord of Appeal in Ordinary, mulling on the idea that the reforms to the preferential status of HMRC in that separate silo in the finance bill is, of course, as he said, what would cause, quote, immense harm, or we might say is deeply problematic for the rescue culture, as R3 have been saying. So if R3 are representatives of the communitarian objectives of rescue, those early Cawson aims in this Cawson age, of course, they're now fighting against that other power interest to try and balance those issues that Mark alluded to. And of course, that silo point is one we might watch as the committee stages go through. So, by way of conclusion then, in my final couple of minutes, internationally, there was only a slight mention, or two peers mentioned us as a forum in the way in which we might think of England and Wales as a jurisdiction. Of course, you had Viscount Trenchard reflecting on the idea that we're 14th in the World Bank's Global Index on Restructuring jurisdictions. And then, of course, Lord Hayne also mentioned some Dutch provisions that might be, in the post-Brexit environment, of course, a competitor set of regulations. So I thought it'd be interesting to highlight that and the idea of to what extent, not just with charities and the power interests, have we also seen perhaps wider global issues reflected in the way in which this bill is being debated and thought through. So, by way of conclusion, it'll be interesting to see if, I've always advocated that we don't have a rescue culture, particularly when you mull on the statistics. You can see there that other company insolvencies at the bottom reflects, of course, administration and CVAs, whereas we have massively prevalent statistics for liquidation. So to what extent will these reforms reflect changes here? Will it even be the case that rescue procedures get their own lines, which we haven't seen for about 5 years now, which of course is noteworthy. So there are my thoughts from the academic perspective. Thanks very much for your time.
Thank you very much, John. Great. I don't think there's anything else. If anyone else wants to ask any questions, if you direct those questions to Jo Stapley, she can forward them to various members of the team who would be appropriate to answer those. All that remains really for me is to say thank you for joining us on this Zoom webinar. Hopefully you've also joined us on some of the 3 earlier ones. It's a massive change to the insolvency landscape that this bill introduces, and we do hope that these sessions have been useful to you in familiarising yourselves with it. No doubt there will be further sessions to come when we see the final version of the bill and we start to see some cases reported off the back of it. But for now, thank you very much for joining us, and we hope to see you at our next event. Thanks very much.